these motions to revoke probation on Jessica Robinson?
Yes, Your Honor. These are ones I think
We having a hearing on that?
I think we're going to plead true and let the court decide what to do.
Right
They're
now?
all administrative. That's you'd like to, right? Yes. Because they're just not reporting and money.
It's technical.
Yeah, it's all technical violations.
What state, what's probation say about this?
Well, she failed to report for the months of June, July, August, and
How
September.
much time does she have acquired, please? I guess that's an important thing. These are all state jail felonies.
Yes.
I think she's been incarcerated 46 days.
It's been since October 17th.
46 days. Your Honor, the probation department was going to ask the court to allow this case to expire this month on the 20th due to her inability to pay, because she's been on probation for 10 years now.
I understand that. That's,
She quit reporting, so we could
Okay.
not address the situation.
that's more of a problem. Is if you don't report, you're not on probation. You're on your own probation, which is not the way it works. Huh?
Total 120 days.
All right. Does the defendant waive formal readings of these motions to revoke probation in each of these cases? Can we proceed and so?
Yes.
And you were Jessica Robinson. Raise your right hand. You have to speak up so she can hear it. Solemnly swear or affirm the statement you make will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Lower your hand. In 13-17068 and 16-24775 and 16-24776, you were on probation as of June 21st, 2016. In each of these cases, as you were placed on 2 years state jail, no, 2 years. No, it can't be easy. It can't be. It's not going to be. You were sentenced to 2 years in the state jail, and that was probated for 5 years in 17068 for the state jail felony of abandoning or endangering a child. Then
I know. I can do it, John.
in 24775, this states that you were sentenced to 2 years in prison, suspended for 5 years for the state jail felony of abandoning or endangering a child. That can't be right. Right? You can't send somebody to prison for a state jail felony, right? And then 24776 states you were sentenced to 2 years in prison, probated for 5 years for a state jail felony of abandoning or endangering a child.
I think you're.
Isn't that wrong?
Yeah, I think it should be a 2-year state jail probated over 5 years. I think the motion maybe.
Is that, does that agree with
Which motion, which motion?
The motion will say TDC versus state jail.
775 and
2 years
776?
in the state jail division of the Texas Department of Criminal Justice, which is right.
It says she was sentenced to 2 years in the institutional division.
Oh, the other ones
In
I
those
have.
two, in these two,
Okay.
and then state jail in this one.
It should follow
Then
that.
we moved to amend and add state jail before those two.
No objection.
Isn't that right? You were in the state jail, correct?
She hasn't gone at all. If she violates that, what her punishment could be.
Was she originally placed on deferred?
That was speculation, right?
Because I saw the judgment said that she pled true on one, that she.
It's 2 cases.
Yes.
She originally used it together.
That was back in 2013, 16, 2013, maybe that one. Yeah, but
The original.
the original one, I think she was deferred on,
I think she referred on that one and it got these two.
because I see a judgment sentence.
Yeah, I think
she
she
pled
did, she
true.
got straight probation, got 3 of them. That one was converted from deferred to straight.
That's why I started so much.
Yeah. Yeah.
On each of these, they similarly allege
It's okay.
that on June 21st, 2016, in this court, you were sentenced to 2 years in the state jail, and that was suspended. You were placed on regular probation for 5 years for each of the state jail felonies of abandoning or endangering a child. Is that all of that true? One states you failed to report to the Jefferson County Probation Office. In each of these motions states you failed to report to the Jefferson County Probation Office for June, July, and August of 2025 in violation of condition 4 of your probation office probation order. And that was the last time you reported. Is all of that true?
Yes.
Are you pleading true to allegation 1 in each case voluntarily and because it is true as it is alleged that you failed to report to the probation office as ordered?
Yes, sir.
Do you understand that 1 or more violations of probation is all is needed to prove by preponderance of the evidence or greater if proven to revoke your probation,
Yes, sir.
and you can be sentenced to no less than 180 days up to 2 years in the state jail? Knowing that, you insist on pleading true in each of these cases?
No.
Is that correct?
Yes, sir.
I find you were pleading true voluntarily in each case, and you understand and appreciate the consequences of pleading true to allegation 1 in each case, which is failing to report to the probation office. All right, there is no agreement here.
No.
Go ahead.
Your Honor, we would ask to continue on probation. She is due to expire on, I believe, the later this month. I'm not sure the exact date. 20th. The 20th.
128 days.
She's behind significantly on fees. She did miss a few dates there, but she has been on probation for a while now and has been doing okay. So I'd ask the court to give her a little more time. I know we can't dismiss this motion of probation because it's about to expire, but hold it in abeyance and let's come back in several months, see if she's making some payments and making some effort towards getting on the right track. I think she knows she needs to, and see if we can get this caught up. She owes, I believe, 4,000, 5,000, something like that.
She owes $4,902.
I was right about $5,000.
How much is she paid is the question.
Your Honor, she's paid $4,564 thus far, with all 3 cases combined.
Yeah, she's paid about half of what she owes, and she still owes more money. She needs to focus on getting this paid as fast as possible. But I would ask.
Showing up and reporting is kind of important.
Absolutely, but she has been reporting in the past, right? These allegations are for those months there you allege, but
No, she walked off the job though.
she didn't finish. She didn't finish. I know. She
Fired,
at
right?
the end she stopped reporting. But I think now if we now that she's gone to jail and sees what it's like, I think she knows she better not do that. So I would ask the court, let's let her out and leave these open because obviously we need to leave them open, and then come back in 3 months or whatever the court determines a good time to come back and see if she's doing anything at that point. She might not be. I mean, we'll know.
What's they say?
Judge, on the original case, looks like she was given deferred and she got those 2 new cases and was given another chance on probation. And we know that reporting is important, that it's one of the most important things that we have to do because we can't supervise them if they don't report. If she gets back out, she's just going to be supervised by the same probation office and have to pay money and do the things that she was supposed to be doing beforehand. So I think a good solution would be, since she's got some jail time, but not the full, that she get 180 days state jail. That way she'll have to do some more time in state jail and probation won't have to supervise her anymore. She'll have her convictions, her time, and going about her business.
It's a long history here.
Yes, sir.
She was on deferred or unadjudicated probation in 13.
Yes, sir.
Then that was changed to regular probation.
Oh.
Why has she gone past the 5 years?
She was extended several times, Your Honor. She had 6 different probation officers before I received the case. So I tried to address it immediately.
The total amount of time credited in her service is 138, did you say?
2-8.
128, Your Honor.
Sorry.
I don't see how keeping her on probation any longer is we've exhausted all the options and we're still coming up with problems. All right, I understand. Anything else to add? Would you like to add anything now? No. Here's then I'm going to find that there is sufficient evidence supporting these motions to revoke probation to grant them by a preponderance of the evidence or greater. As allegation 1 has been proven true in each of these cases by a preponderance of the evidence or greater, since the defendant has admitted failure to comply with the reporting to the probation office as required, and allegation 1 in each case is proven true. Thus, the motion is granted. Your probation is revoked, and you are hereby sentenced to confinement in the state jail for 180 days, which is the minimum. You will be given credit for all time you have served. And these will all run concurrently, as you know. And hopefully you can move on with your lives with this. I think that is in the best interest of justice under these circumstances. That is all. All right, what else? Yeah. 24 CR 777. That's good luck. In Haiti, I think. Is called here in this case. You are Christian Armani Simeon, correct? Here with Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed to summary?
Yes, sir, please.
In summary, this indictment alleges a most serious charge that on or about March 5th, 2024 in Jefferson County, Texas, you committed the first-degree felony of aggravated robbery with the use or exhibition of a deadly weapon, namely a firearm. Do you understand what you're charged with here?
Sure.
If convicted of a first-degree felony, you face a term of life in prison or any term of years of not more than 99 years in prison or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
Going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1. Part of the record for all purposes. Pre-sentence report is waived.
Yes, please.
I'm going to follow this agreement. Stand by just a second. All right. Um, looking at this probable cause affidavit, so, okay. So two people, this defendant and Javon Sims go to get a haircut from somebody. And then according to this probable cause affidavit, Sims displays a rifle, demands a firearm that is owned by the person who's going to be given the haircut. During this incident, the defendant is in the bedroom attempting to steal the victim's gaming system. And at this point, the victim is in fear of his life, presents I guess, pulls a firearm and shoots the Sims, and then both subjects escape. Sims gives a confession that he did commit the act of aggravated robbery, and then Simeon here was with him. Okay, all right. That's all there's said. There's not a lot of depth here,
Right.
you know. So
That's why deferred was offered in this case.
I understand.
Yeah.
But in conditions of probation, what this court normally does is I put people in jail for up to 106 months, which I can do as a condition of probation when there's an aggravated crime that's being committed, especially when you're, yeah, I mean, this is all too often a problem, and that's why this court does what it does. And I say, you commit a violent crime, you're going to jail. You just go to jail. You made it. You've signed your contract. That's what happens. You're held accountable. And deferred or unadjudicated probation includes confinement up to 6 months. What's the state say on it?
Judge, if the court finds that that's appropriate, an appropriate condition.
Whenever an aggravated robbery is committed.
I would argue against it for
Why?
well, in the sense that he's not the one that had the gun. If he had the gun, then I would not argue it at all.
Did he commit aggravated robbery as a party?
Just by law of parties because he was there with it.
Just by law of parties, but I mean,
No.
the legislature enacted that for good reason.
That's why
They just don't include people who are in the area code.
I know.
He had an affirmative act that he took part in, knowing that it was going to, that whether he held the gun to the guy's head, whoever's holding it to somebody's head,
Right.
they and everybody helping that person are held accountable.
I understand that. My other argument in this case is Mr. Simeon has been on bond this entire time. He has never missed court. He's never had a
No,
problem.
but that all did not prevent him from committing a crime.
I
He's not going to be punished for being good on bond.
I know, but I'm saying there's other factors I think the court needs to consider that this is a little different than a lot of times what we see. And I understand the court does do this a lot of these cases. And like I said, if he had the gun or the primary, I don't want to use the term primary, but the person had the gun, I wouldn't even be asking anything of the court. I know what the court would do. But I think it's a different situation. He was there. This whole thing went down. I don't think he ever knew this was going to happen. At least I've talked to him several times. He had no idea this was happening or going to happen. It wasn't intentional or didn't go there with that intent. But it did happen. He was part of it.
How was he part of it if he didn't have intent? You're about to talk out of a deal here.
Well,
You know that.
I know.
He either committed the crime or didn't. And he had to have a culpable mental state to go along with the law of parties. He helped him or not. What did we do? If you didn't help him, you didn't. We're going to trial. Let a jury try it. Hey, you've said enough. You know what you just did. You've walked this thing out of the.
Let me finish. I haven't finished the rest of it, Your Honor.
Yeah.
I didn't say he didn't go there with the intent to armed robbery, the intent to steal the item, which actually did happen. We know that. Okay, that's what we talked about. But then the gun got pulled. I don't think he knew that the gun was going to be pulled, but he still went along with it and still continued with the process.
How did he do that? How did he get involved in the law of parties for aggravated robbery?
Because he was the primary person. Mr. Sims was using the gun to steal.
He had to.
Apparently, gun. Okay. Right. Okay.
But what that said,
he was stealing out of the other room, stealing the gaming system. It was Xbox, right? Or was it PlayStation? Right. The gaming system, and then it all evolved from there, Your Honor. Then
Let's read the belong parties, just so you know what you've done here.
And if the gun would, when the gun would pull up, he would have walked away or stopped, then he would be out of that. But when he continued on with what he was doing, that includes him with law of parties.
Mere presence of the defendant at the scene isn't enough, but it is circumstance combined with other facts that may show that he was a participant. He is criminally responsible for an offense committed by the conduct of another if acting with the kind of culpability required, he causes or aids a person to engage in conduct, acting with intent to promote or assist the commission of the offense. He solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Okay, culpability is all part of those.
Yes, and he was
But he
still
said
stuff.
he didn't do any, he wasn't there to do anything.
I think they were there to steal stuff. I don't think he initially knew that there was a gun involved, but he didn't. When
He
the
had
gun
to
came
solicit, encourage, direct, aid, or attempt to aid the other person to commit the crime of aggravated robbery. What did he do to help
out,
commit
he
the
was
crime of
he was taking
aggravated robbery?
items. While the guy had a gun out, he was taking items. Therefore, he becomes part of it. I'm just saying that I don't think his intent when they got there was to use a gun, and they were going there to steal stuff. Sure. But when the gun came out, he didn't abandon it, which would at that point.
What did he do other than just be present? What is it that, what
Taking
affirmative
items
acts did he
with the-
take?
with the other
It's
guy
part of
having
the
a gun.
robbery.
Yeah, he was taking items. That's part of a robbery. When you're taking items that don't belong to you.
Could you go over that again? I guess I was slow in school. Is that right?
He was
No,
committing.
I'm just
the-
kidding you
I
about
know he was taking
No, he's
items.
gotta have a culpable, he's gotta have a bad, mindset.
Taking stuff
So
is
what
a
did
bad
he
state
do?
of mind. Stealing stuff from people is a bad state of mind. And then when the gun came out, he didn't.
Did you know he was gonna rob the guy or not? Surprise.
Yeah, I agree with my outfit because he came there with me. Was
That's
he
the
was my
only
friend,
reason.
he was my friend, so he came with me, so I'll take the night for that. Because if I would never brought with me, nothing would have happened. Since I brought with me, it's my fault.
It was, okay. You're pleading guilty because you think you were a friend of his, because of your friendship.
Oh, no, sir.
Yeah, that's not the test. You have to have done some bad things as part of this crime of aggravated robbery.
Yes, sir.
What did you do?
They claimed that I grabbed things.
No, well, I don't care what they
Yeah.
claimed.
Well,
What
yeah.
did you do that was part of the robbery, sir?
I didn't know I was in the bathroom. I went to go grab a lighter. Then that happened. Two people didn't like the way each other was looking. Then that happened. I heard a gunshot out the house. Like that, so
Anything else? All right, we'll set it for trial.
Okay.
That's all we can do. He doesn't, the record didn't support it. He's not admitting guilt or culpability here. It'll be set for trial. We'll let a jury decide your fate. Okay. And they don't give probation. But anything else?
sure.
That is all. No, it's set for trial. You talked yourself out of, you're not responsible. You're not guilty. And that's what you made it clear. We can't accept a guilty plea when it's not guilt. You didn't do anything wrong according to you, except steal some stuff in the other room. It's the other guy's fault. So we'll let a jury decide. We'll set it for trial. All right. That is all. Thank you.